the Bar Association to invite me, and of course, I think we'll need many more sessions on these three legislations, considering all the various nuances that have been now introduced. So, ladies and gentlemen, uh, today, as we stand on the precipice of the new Bharatiya Nyaya Sanhita, it is imperative that we delve into the annals of history to understand the journey that has led us to this pivotal moment. The roots of our legal system, deeply embedded in the history of India, stretch back to the 19th century, a period marked by significant transformations, upheavals, and the birth of ideas that would shape the course of our national legal landscape. Between the years 1833 and 1862, India witnessed a tumultuous era characterized by colonial rule, societal change, and the gradual awakening of the nationalist sentiments. It was during this time that the Penal Code, a cornerstone of our legal framework, came into existence. To comprehend the genesis of this monumental legislation, one must first grasp the historical backdrop against which it emerged. The early 19th century saw India under the governance of the British India Company, a period marred by exploitation, economic policies favoring the colonizers, and the erosion of the indigenous systems of governance and justice. However, it was also a time of intellectual ferment, with the seeds of reform and resistance taking root amidst the prevailing turmoil. The penal law and procedure varied from princely state to princely state and from presidency to presidency, with differences in the punishments for the same offense, to acts being offensive in some areas but not in others, or ingredients being different from place to place. Central to the formulation of the Penal Code was the establishment of the first Law Commission of India in 1834, tasked with the monumental responsibility of consolidating and codifying the laws of British India. Led by luminaries such as Lord Macaulay as chairman, the commission had four other members, namely Cameron, Macleod, Anderson, and Millett. The first three members represented Madras, Bombay, and Calcutta, respectively. The commission was assigned the task of codification of the laws. Based on a simplified codification of the law of England at the time, elements of the Penal Code were derived from the Napoleonic Code and Louisiana Civil Code of 1825. Lord Macaulay thought the basis for such a code should be, and I quote, uniformity where you can have it, diversity where you must have it, but in all cases, certainty. He also felt that such a code was the only blessing which an absolute government is better fitted to confer on a nation than a popular government. The members of the commission prepared a draft penal code which was submitted to Lord Auckland, the Governor General, on the 2nd of May 1837. It could not be immediately enacted into a code as there was confusion in relation to the substantive civil laws and the laws of procedure and various other reasons. Multiple Governors General of India felt that reforms were not needed and opposed the new law. The IPC project was delayed by the governmental and legislative inertia, resistance by European residents to having the same legal status as indigenous populations, and the loss of reforming momentum in the metropole. The first final draft of the IPC was submitted to the Governor General in 1837 and was drafted and redrafted until finally the draft then underwent a very careful revision at the hands of Chief Justice Barnes Peacock, who became a member of the Governor General's Council in 1852. The year 1857 stands out as a watershed moment in Indian history, marked by the Sepoy Mutiny, also known as the First War of Independence. The uprising, fueled by grievances over colonial exploitation and cultural insensitivity, underscored the simmering discontent beneath the surface of British rule. Although the war was eventually quelled, its reverberations echoed across the subcontinent, galvanizing the nascent nationalist movement and laying the groundwork for future struggles for independence. Soon thereafter, the Indigo Farmers' Revolt erupted, primarily in the Calcutta region, which was then the capital of India. The revolt of 1815 was a movement of peasants and farmers against the British planters who forced them to cultivate indigo instead of other crops on their land. Indian farmers were frequently oppressed to cultivate more crops. With the 1857 revolt as well as other uprisings came brutal reprisals that fundamentally shook British claim of enlightened rule in its colonies. Following this, When the British Crown took over the reins of India from the East India Company in 1858, it felt that such a law was necessary to quell any future rebellions and punish the locals as per British law. According to one scholar writing on Macaulay, the English political classes saw the legitimacy of British rule founded on the claims of constitutionalism and the rule of law undermined by such repressive responses. Enactment of the IPC helped to address these concerns. The IPC came to be passed in October 6, 1860, effective 1862, as a reaction to the events referred to above, heralding a new chapter in India's legal history and ushering in an era of codification and consolidation under British colonial rule. With the establishment of the Chartered High Courts on June 26, 1862, the dominion of law and judiciary over the entire territory was extended across the length and breadth of the subcontinent, cementing the authority of the colonial state and paving the way for the enforcement of legal norms. And amidst the tumult of the 19th century, visionary leaders such as Bal Gangadhar Tilak, Mahatma Gandhi, Jawaharlal Nehru, B.R. Ambedkar, and various others were born. Their indomitable spirit and unwavering commitment to justice and equality served as beacons of hope in a dark and oppressive era. Now, in contrast to the 19th century milieu characterized by colonial dominance and traditional modes of justice, the 21st century has witnessed a seismic shift in the legal landscape, propelled by technological innovation, globalization, evolving societal norms, and a strong judiciary with visionary judges. The Supreme Court in the last 75 years infused the penal code with constitutional principles under Article 21 and elevated principles of fair investigation and trials to a fundamental right. Though there have been various amendments from time to time, there has never been a substantial overhauling of the penal code. The law made in the 1860s has stood the test of time, making it the longest surviving code in common law world, perhaps a testimony to how well thought out it was at the time of its creation. However, alongside these remarkable advancements, the post-independence 20th century has also witnessed emergence of new challenges and complexities ranging from crimes against the economy, organized crime and terrorism to gender-based violence and sedition. The need for robust legal frameworks underscoring the imperative of legislative reform and innovation in pursuit of justice and security for all, as indicated by several specific legislations were promulgated to deal with the emerging offences of that time. It is against this backdrop of historical legacy and contemporary imperatives that we must examine the significance of the new Bharatiya Nyaya Sanhita. Building upon the foundations laid by our forebearers, this trinity of legislations, which we are discussing tomorrow also, to reconcile it with the exigencies of the modern age. The use of technology for the purpose of investigation as well as in the process of judicial proceedings has become critical in the last few years. The proliferation of technology has revolutionized every facet of the justice system, from legal research and case management to forensic investigation and dispute resolution. The use of artificial intelligence, big data analytics, and blockchain technology holds the promise of enhancing efficiency, transparency, and access to justice, hopefully heralding a new era of legal empowerment and accountability. The advent of new legislation such as the GST, the data protection laws, the IBC reflects the changing contours of governance and economic policy in a rapidly transforming world over the last few years. And also with the changing landscape of the number of prosecutions under special legislations, it is possible that the government has taken into consideration some of the changes in the tapestry of offences, for which we will hear something from our learned Member of Parliament. Now, for example, in 2003, the number of prosecutions under TADA and POTA was 325. This is all NCRB data. And the number is now at about 1,000 under the UAPA. With offences like sedition, which had caught the imagination of the nation with the trials of Bal Gangadhar Tilak and Mohandas Karamchand Gandhi having become less relevant in the post-independence era, its misuse as a political tool to prosecute persons critical of the government and its policies, there has now been a reduction in the number of prosecutions relating to sedition in 2022. Now, coming to the penal code itself, on a simple textual comparison, it is evident that a large portion of the IPC has been retained verbatim in the BNS. The introduction of new offences and the importing of offences from other legislations with some changes, and deletions of IPC offences have important implications that need to be assessed. 511 sections of the IPC have now become 358 sections. Only about 17 new offences are added, 9 of which are by way of subsections to the existing sections. 144 sections got amended largely due to increase in punishments, and about 198 sections have remained unchanged. The numbers have reduced primarily due to combining and reorganization of section numbers, and further, a total of 14 offences and 5 definitions have been deleted. But dealing with some of the important changes, because it's impossible for us to go through the entire legislation, I chose to pick up a few by way of an illustration. One of the new offences introduced in the Sanhita is the offence of terrorism. Section 113 of the Bharatiya Nyaya Sanhita has introduced the offence of a terrorist act. Presently, offences relating to terrorism are dealt with under the UAPA. The offence under the BNS is identical to the offence under the UAPA, and we will hear more, I hope, from Mr. Kumar. Interestingly, though, BNS recognizes life imprisonment without parole, the Parliament has chosen not to introduce this punishment as a punishment for a terrorist act. The only distinction is that under UAPA acts and organizations which are recognized under international treaties and which are included in the act and notified under the UAPA would be considered as terrorist activities, but those class are not included in the BNS. There is no clarity as to why these parallel provisions are made to coexist, because the repeal and savings doesn't repeal the UAPA. Though the explanation of the section provides that an officer not below the rank of a superintendent of police shall decide whether to register a case under this section, that is the BNS, or under UAPA, there is no clear reason as to why it would be decided and to which statute, and why the power is given to the superintendent of police to decide whether to invoke the BNS or it's a matter which should go to the UAPA. Though the Supreme Court in Hitendra Thakur indicated that terrorism extends beyond the effect of an ordinary crime, which is capable of being punished under the ordinary penal law of the land, its main objective is to overawe the government or disturb the harmony of society or terrorize people and society at large, not just those who are directly assaulted. The fallout of the intended activity must exceed the capacity of ordinary law enforcement agencies to tackle it under the ordinary penal law. Yet, a specialized offence has made its way into the general criminal law, which is the BNS. What distinguishes terrorism from other forms of violence is the deliberate and systematic use of coercive intimidation. Often a hardened criminal takes advantage of the situation and by wearing the cloak of terrorism aims to achieve acceptability and respectability in society. It is therefore necessary to treat such criminals differently than an ordinary criminal capable of being tried by ordinary courts under ordinary penal law of the land. While the crime committed by a terrorist and an ordinary criminal may overlap, it is not the intention of the legislature that every criminal should be tried under the special anti-terrorism laws like UAPA, where the fallout of that activity does not extend beyond the normal frontiers of ordinary criminal activity. By introducing the offence of terrorism under the regular law, it would appear that such distinction has been done away with. One wonders why. This offence also brings within its scope economic security. Unlike the UAPA, it is not defined under the BNS. Economic security is not defined. But the High Court of Kerala, in Muhammad Shafi's case, gave a restrictive meaning to the offence of terrorism in relation to economic security under the UAPA, limiting it to the offences such as counterfeiting currency. However, without any definition under the Indian Penal Code, a wider meaning could be given to economic security. Considering the width of the phrase, any form of financial activity could, at the whim of a police officer, be categorized as financial terrorism and could be included within economic security. This could include recent incidents like the Hindenburg shorting of shares on the Indian Stock Exchange, which caused the stock exchange to drop by a significant number of points and in a week lost about $100 billion in market value. It could include cases like the attack of George Soros on the Asian and UK currencies in the mid-90s, which was known as the Asian flu, or a silver shot by the Hunt brothers in 1980, It would include the Bofors scam, the Augusta Westland scam, the Harshad Mehta scam, the ILFS scandal, may also be considered as threats to the economic security of the country and could be included under this offense of terrorism. However, if we want to protect foreign investments, and I say this to my learned friend here, if we want to protect foreign investments and be an open economy, a restricted meaning ought to be given to economic security under this offense to avoid the misuse and abuse of this provision. Although the offense of terrorism under UAPA is a scheduled offense under the NIA Act and is investigated by the NIA, investigation of the same offense under the BNS can be conducted by a state or local police. Another new offense created by the BNS is the offense of organized crime. Section 111 and 112 introduce organized crime as an offense under this central law. Organized crime is penalized in some states through state legislations like the Maharashtra Control of Organized Crime Act. The definition of organized crime is identical to the definition in the MCOC. Like offenses under state legislation, it includes a continuing unlawful activity carried out by groups of individuals acting in concert, either singly or jointly, or as a member of or on behalf of an organized crime syndicate by the use of violence, threat of violence, intimidation, coercion, corruption, or other unlawful means. Filing more than one charge sheet in respect of an activity within a period of 10 years against a group of persons and where the court has taken cognizance would make such individuals part of the continuing unlawful activity group. The BNS now specifically includes economic offences within the definition of organized crime. Economic offences have been defined in the section to include criminal breach of trust, forgery, counterfeiting of currency notes, bank notes and government stamps, hawala transactions, mass marketing fraud, or running any scheme to defraud several persons or doing any act in any manner with a view to defraud any bank or financial institution or any other institution or organization for obtaining monetary benefits in any form. This has serious implications again at the level of protecting business and a thriving and growing economy. If a group of individuals are charged with cheating a bank and multiple charge sheets are filed, it is likely that such person could be charged under the organized crime offense. Take the example of consortium lending by a consortium of banks. If there is a default by the borrower of a consortium loan and each member of the consortium files a case for which separate charge sheets are filed, this may be an unlawful continuing activity and could come within the scope of organized crime. Other examples are cases of Ponzi schemes like chit funds, plantation schemes, home buyer frauds, and multi-level marketing schemes. The makoka itself has been used as a weapon on occasions to settle commercial disputes with persons filing false complaints of extortion in property disputes under the makoka. The Supreme Court has held that makoka could be applicable even in the context of the Essential Commodities Act, but added one additional caveat. To apply the provisions of makoka, something more in the nature of coercive acts and violence is required to be spelt out so as to bring the unlawful activity complained of within the definition of an organized crime. So the element of violence was there. But would this observation be relevant with the inclusion of the above explanation that includes economic offences where there is no violence and there is only a fiscal or a monetary implication? Another issue is whether the passing of these laws would be treated as a deemed repeal of the earlier legislations of the MCOC or the UAPA. The Supreme Court in the case of Bharatiya upheld the MCOC, saying that the state's legislature's power to enact the law was based on entries related to both the state and the concurrent list. The MCOC was enacted on the basis the power of the state to enact the law was based on entries relatable both to the state and the concurrent. So, how will we now deal with this particular issue where the definitions are identical in both the legislations and what is going to be given priority? It is also possible to argue that a state law being a special legislation, the same may have to be given precedence over the general law, which is the BNS. 26 of the General Clause Act gives the state the option to decide under which law to prosecute. So then there is another offence, petty organised crime. This is a brand new offence. It is newly introduced offence which aims at dealing with gangs or groups involved in lesser crimes. It penalizes minor offences such as theft, snatching, and similar activities undertaken by a group either individually or collectively. However, the term criminal group or gang has not been defined. The explanation to the clause lists certain types of theft, there is again a definition, which including trick theft, theft from vehicles, dwelling houses or business premises, cargo theft, pickpocketing, theft through card skimming, shoplifting, theft from ATMs. But there is no pecuniary limit set for these crimes. So how are they petty organized crime offences? If these offences are part of the petty organized crime, which is all these explanations of theft which I just told you, will they be excluded from the organized crime activity offence itself, which is under 111? So we have now a very peculiar situation where you don't know whether you're under 111 or you're under 112. But we as lawyers will certainly ask for the exclusion from the 111 if it is included in the 112. But traditionally, under the MCOC laws, all of these were all treated as part of organized crime activities. So I have not understood, again, the reason for these very fine distinctions that Parliament has sought to bring in. Then the offence of sedition has been omitted. However, the BNS now seeks to criminalize acts endangering sovereignty, unity and integrity of India, punishing them with imprisonment for life or imprisonment up to 7 years. At first glance, this appears to be an offence similar to 124A, but with a minimum punishment which is increased from 3 years to 7 years. But a closer look at this provision shows that it is essentially a recreation of the offence of unlawful activity punishable under section 13 of the UAPA. So now you brought section 13 of UAPA into the general law as if it's a substitution for 124A, but the definitions are identical. The offence under the UAPA is broader, dealing with cessation of a part of a territory of India or a separatist activity, unlike sedition, which dealt with disaffection towards the government. It criminalizes actions which seek to incite or excite secession, armed rebellion, subversive activities, or encourage feelings of separatist activities endangering sovereignty or unity and integrity of India in place of a mere disaffection towards the government. However, without a legal definition, terms like subversive activities remain vague, potentially criminalizing legitimate protests and dissents against government. This lack of clarity indicates a need for judicial intervention similar to what was done with the offence of sedition to avoid its misuse and to avoid its impinging on the Article 19 rights. Similar to terrorism and organized crime, the purpose of enacting a similar offence in which is already present in the statute book is again not clear. The procedural safeguards provided in UAPA and MACOCA are not available under the BNS. These safeguards, such as allowing senior police officers to investigate a terrorist act and mandatory sanctions from the state or central government before cognizance can be taken of a terrorist offence, play an important role in checking the abuse of power. The state legislations provide various checks and balances for invoking the provisions of the statute, like the FIR cannot be recorded without a senior officer's sanction, investigation to be done by a senior officer, and sanction prior to taking cognizance. But none of these safeguards find themselves in the BNS for the identical offences which have now been introduced. However, equally, and of course I think the legislature is very uniform in its approach to life, however, equally the deviation from the BNS is that the UAPA and MACOCA severely restrict the rights of accused and enlarges the state's powers, particularly regarding anticipatory bail and remand periods during investigation, which are more favorable to the prosecution. Evidence collected through interception of wire, electronic or oral communication can be relied upon by prosecution under UAPA along with mandatory presumptions in evidence that are applicable to offence of terrorism. But these provisions are also absent in the Nagarik Suraksha or the BNS, and therefore we now treat all these offences like a normal criminal offence, which will be with 15 days of custody and with a maximum of 90 days, unlike all the other provisions. The twin conditions which have actually worried the country are no longer applicable to terrorist offences under the BNS. I think there's something good that came out of this. The BNS then, and let me take another section of offences. The BNS introduced a new chapter titled Offences Against Women and Children to address sexual offences. Similar offences under the IPC were part of the chapter on offences affecting the human body. The implication of such restructuring is that sexual offences are only recognized if committed against a woman, and that too only by a man. In IPC, rape is a gendered provision, where the offender can only be a man and a victim a woman. This is despite the statement of objects and reasons of the BNS, mentioning that various offences have been made gender neutral. But this does not apply to the offence of rape. Only two provisions under the category of criminal force and assault against women have been made gender neutral, which is section 76, which is assault or use of criminal force to women with intent to disrobe, and section 77, which is voyeurism, which now opens with the word whoever, unlike in the IPC where it was any man. The BNS for the first time includes transgender within the definition of gender to have the same meaning as in Transgender Persons Protection of Rights Act 2019. Therefore, whenever the term he has been mentioned, the same is to be construed as including transgender persons as well. However, curiously, transgender individuals have been excluded from the purview of the definition of woman or man, and hence a sexual assault by or against a transgender is not recognized as rape. Another aspect of the new act is that it completely misses out on the assault and rape between persons of the same sex. Earlier, such offences were brought within the purview of section 377. The consensual sex amongst persons of the same sex, which was also criminalized under the section, was decriminalized in Navtej Johar's case recently. The Supreme Court was careful at the time of the judgment and held any act of the description covered under section 377 IPC done between two individuals without the consent of any one of them would invite penal liability under section 377 of the IPC. Similarly, so please mark it, any act done between two individuals without the consent would be covered under 377, which is effectively rape. Similarly, the Supreme Court held, however, if any one, by which we mean both a man and a woman, engages in any kind of sexual activity with an animal, the said aspect of section 377 is constitutional and it shall remain a penal offence under section 377. The BNS, however, misses both and excludes sexual offences between persons of the same sex and also excludes bestiality because 377 is one of the omitted sections under the Act. Another significant change is that the age of consent for a married woman under the definition of rape is increased from 15 to 18. This change seeks to implement the Supreme Court's judgment in independent thought, where the Supreme Court struck down the exception 2 to section 376, which provided immunity to a husband if he had sex with a wife who was above 15 years of age as discriminatory and violative of Article 14. However, the Supreme Court refrained from making any comments on marital rape. There was a need to consider the marital rape exception, which the legislatures have chosen not to address. The legislatures also missed addressing the archaic provision under section 98 explanation 2, which permits sexual intercourse with a minor wife. While dealing with punishments, all these offences provide for a minimum of 10 years. Considering societal evolution, there is a need to vest discretion in the sessions judge to impose punishments lower than the statutory minimum when circumstances warrant it, especially in cases involving sexual offences. The BNS criminalizes sexual intercourse based on deceitful means, such as a false promise of employment or marriage. Sexual intercourse based on a false promise to marry, which was previously considered rape, has now been categorized as a separate offence under section 69. Sexual intercourse by employing deceitful means, it penalizes sexual intercourse based on deceitful means, which includes the inducement for or false promise of employment or promotion or marrying by suppressing identity on a promise to marry a woman without having intention. The Act also does not penalize sexual assault committed on a transgender. So what you all will see here is the earlier principle for introducing this whole element of false promise to marry within the domain of rape was the question of the absence of consent is how the Supreme Court interpreted it. So when you look at this provision of rape today, it's all about absence of consent. But since there's an inducement, they've now treated this as a separate category of an offence because there's an implied consent by means of an inducement. So they've just categorized it as a new offence. So in recent years, We have embarked on a transformative journey in our legal landscape, prominently featuring the decriminalization of various offences through legislative means such as the Companies Act and the Jan Vishwas Act. By aligning our legal framework with contemporary societal needs, we ought to have embraced a more progressive, pragmatic, and humane approach reflecting a nuanced understanding of justice and social change. However, the BNS failed to make use of the opportunity to decriminalize many offences. There's one major, and if I may just say in conclusion, there's one major and serious lapse in my view. There are no provisions dealing with offences relating to the internet. The Information Technology Act is limited in its creation and application to offences. However, given this opportunity, the BNS should have included a Bharatiya Abhashi Digital Dand Sanhita. In conclusion, if I might say that the penal code introduced by Lord Macaulay in the 19th century has undeniably stood the test of time, emerging as one of the longest surviving codes in the common law world. Despite the passage of decades and numerous societal shifts, many of the offences outlined in the original code remain relevant today, a testament to its enduring wisdom and foresight. The fact that substantial overhauling of the penal code has never been deemed necessary speaks volumes about its efficacy and adaptability to changing circumstances. Its resilience in the face of changing times is a tribute to the meticulous craftsmanship of its architects and the enduring relevance of its principles. And therefore, if I may only say, because let me tell you that there's a lot in the BNS which can't be covered in this very limited time. I just thought I should share some of my views about the some of the inadequacies, if I may call them, of the BNS, where there was an opportunity after 75 years of law being developed to introduce within the BNS provisions which take care of the principles that have been evolved by the Supreme Court over the last 75 years. But I'm sure that as all of us here will see this as a great opportunity as young lawyers to now keep interpreting this entire law which will keep us going for the next 100 years, and there'll be enough chaos and confusion, if I'm sorry to say, when there was an opportunity, in the words of Lord Macaulay, to say that there should be certainty in the area of criminal law. Thank you very much, and I think the Bar Association has a lot more to do with various other provisions of the BNS, because I've just touched the tip of the iceberg, and I'm sure that this will continue. Thank you very much.